Good afternoon, ladies and gentlemen. My name is Jerome Deering, and I'm co-founder and program director of rcsnow.org. The program that we're presenting today is called Crime and Awareness, the impact and effect it has on communities of color. And with that, I will proceed with my presentation. Hopefully you will glean something from it and take the information that we provide and utilize it to assist you understanding what you can do for your community, but most of all, protect your children. All nationalities of people are impacted and affected by crime, distribution of drugs, gun violence, a whole assortment of activity. Most lack the basic understanding of the consequences of criminal conduct as prescribed by federal statute and state code. Unfortunately, you have elements engaging in criminal conduct that understand little of the ramifications of their conduct. What rcsnow.org tries to do is to put information out there and educate them about the choices that they make. Because each choice that a young individual may make who has never had a run-in with the criminal justice system will hinder any future ambitions that they might have. Now, true enough, there are a few that fall through that particular crack and go on after encountering the criminal justice system and become successful at the things that they want to pursue in their lifetime. Perpetrators have always been in abundance. It's the history of our country. Crime has always been an essential element of lexicon of political politicians and lawmakers. rcsnow.org understands this political lexicon of lawmakers. Despite the debate, the discussion, the attempt at resolution. And I say that simply because right now you have a lot of elements in our communities and in Washington, D.C. that are attempting to resolve some of the sentencing practices that have taken center stage based upon the increase in violence and drug distribution here in America. Most people want to be entertained by the stories of prisons, the ensuing violence the ensuing violence of prisons and the deprivations which occur in most prisons. Though alluring to the unconscious mind, it is not alluring to the purpose and intent of rcsnow.org. We are not here to entertain. We are here to inform and educate you. Life and your place in it is a struggle every day. Every day you hear about inflation. Every day you hear about the uncertainty that's going on across the globe. And I've said this in previous episodes that we have put on. And it appears to get worse and worse every year. And I'm not here to judge the perpetrator of crime, nor to condemn the lawmakers who prosecute them. My task is simple: inform and educate in the raw, from a view that I understand. I believe that the gift of understanding is the treasure of God, and He provided each individual with his portion in what measure seemeth good unto himself. And with that being said, I say that solely on the fact that everybody's understanding is not the same. Everybody thinks differently. Some people gravitate toward doing the right thing. Some people gravitate toward crime and punishment. With that, I would like to say that we did an episode called Gangsters and Innocents not too long ago. And it dealt with unconstitutional laws being passed by the Senate and lawmakers who proposed certain laws to try to curtail certain criminal activity. And Mr. Chuck Brewer brought up the fact that in the state of Iowa, they had invalidated a law that had two elements at the time that the law was being utilized to prosecute people who were charged with first-degree murder in the state of Iowa. But the individual that had the two elements, I think his name was a Mr. Hemster, came back and challenged that law, and the Iowa Supreme Court sided with him and overturned his conviction, and he was subsequently sentenced to the lesser-included offense because, like I said at the beginning, that state charge had two different elements in it, and the attorney that represented him on appeal and to the Supreme Court challenged the validity of the two elements, where the intent was different. First-degree murder carries a life sentence in prison, and I think the willful injury at that time may have carried 10 years at the most, and he got the lesser included offense. And the reason why I'm speaking to that today, because since the episode that me and Mr. Bruton did on that particular issue, I went back and thought about all the other unconstitutional laws that have impacted and affected our loved ones who are incarcerated or had been incarcerated under the same scenario that we had talked about in the previous episode. And a couple of the cases that stood out to me were the Johnson cases. There was 3 of them that overturned what is called 18 U.S.C. on federal statute 924E. That's an armed career criminal enhancement. And what that basically means is that if you have 3 prior convictions and you get convicted with a firearm in your possession, then they can give you at a minimum of 20 years in prison, 25 years in prison, or 30 years in prison, depending on the elements of the initial charge. So, Johnson, the 3 Johnson case, one in 2010, I think the other one was in 2015, and the last one was in 2019. The Supreme Court of the United States went back and invalidated the 924, the enhancement provision, because the enhancement provision was, as the Supreme Court case law came down behind that, arbitrary, vague, and being based upon the use. It fell up under what they call the force clause or the residual clause. Now that might be over some people's head, but again, if you're out here toting pistols, if you're out here shooting or doing anything that involves a pistol and you have 2 prior convictions, then you're subject to these type of enhancements. Depending on what clause of the enhancement provision the enhancement falls into. So, and again, that was the force clause, the residual clause, and under the 5th Amendment of the Constitution, which is called due process, the Supreme Court ruled in those 3 cases that an individual didn't have the right to due process if he didn't have an opportunity to argue at trial or on appeal the facts relied upon to enhance them during the course of a trial or a guilty plea. Now, what that basically means is, again, when the Supreme Court or the Iowa Supreme Court invalidates the law, the effect of that law could have a potential benefit for anybody that's pending what is called a direct appeal. You can also take your case after direct appeal to the Supreme Court, either one, Iowa, New York, on the state level. And your chances of prevailing at that point, if one of the higher courts, which is the Supreme Court, passes or invalidates a law that they deem to violate your constitutional right, then you'll receive the benefit of that as long as you're not beyond the Supreme Court phase of your proceedings. Most individuals, as I alluded to in my view, I think that was August 8th of 2022. I talked a little bit about guilty pleas and things of that nature and how it diminishes your ability to get back. So getting back to the Mr. Hemster case, and what me and Mr. Bruton had talked about during that was, he didn't see how a law could be invalidated and held to be unconstitutional and not be applied to everybody that was affected by that law. So we got into a discussion about the law being applied retroactively so that it benefits everybody who were prosecuted and sentenced to prison under that particular law. And that's the sticking point right there. It, again, going back to the phase of the procedural process that you're in, depends on whether or not you could potentially benefit from a disfavorable law. Waiving your rights, giving up your direct appeal, and things of that nature stymies any hope to get a guilty plea or a conviction by a jury overturned. Once you give up those rights, or you're behind the procedural aspect of your criminal trial process. That's what that's called. You hear a lot of people that know the legal jargon talk about a 2255 or a 2254. The 2255 is for federal prisoners, and the 2254 is for state prisoners. And you need to have a general idea of what that means. And that's a discussion for another day. I would hope that none of y'all who are currently incarcerated, or you have family that is currently incarcerated, have suffered the consequences of not receiving the benefit of the Johnson issues dealing with the 924E. Every year you see something on 18 USC, that's a federal statute, 924E, it deals with enhancement. Every year something's coming out on that law. Slowly but surely the Supreme Court has rescinded the application of that 924E. I remember a time in the 70s and the 80s, they could just charge you with it at sentencing. But the indictment requires, the Constitution requires, that it be charged in the indictment now, and it has to be presented to a jury. And what that means is the facts supporting the enhancement has to be put before a jury. And if the attorneys on both sides don't present compelling arguments on why that enhancement provision should be imposed upon you, then the jury can rule that it doesn't apply based upon what is has been mostly used is old state laws that were vague and arbitrary, didn't have the what they call a mens rea, M-E-N-S-R-E-A, and they're not a conjoined or combined word. They're two separate words, and you can look that word up if in fact you have a loved one in jail, pending trial, considering a guilty plea, or if you have somebody that's incarcerated in a federal or state prison that has been subjected to that type of application. All crimes, based upon our Constitution, has to have an element. And those elements are writ out in the charging instrument, which is called an indictment. On the state level, it's called a complaint. So, as we go forward and discuss these type of issues, we want to ensure that you have enough information so that when you call the attorney's office and you're speaking for your loved one about what's going on, what's happening with this, what's happening with that, you have some clear conception of what you're speaking to that attorney about. But most importantly, is that you understand what the attorney's saying to you. Because attorneys are just like anybody else. They're in it to win it. And I'm talking about from the career aspect of it. You have more attorneys doing court-appointed cases than you do receiving a retainer. So if you're, upwards to where that you can afford $200,000 or $300,000 as a retainer, then your chances of getting a lesser sentence is so much better. But if the court has appointed an attorney and the court is paying the attorney, your chances of getting that benefit of a lesser included offense, if in fact you're guilty of the crime you're charged with, your chances become minuscule. So with that, we're going to take a 2-minute break, and I'll be back. Thanks for welcoming me back into your homes or your viewing apparatus. As I was saying prior to going to break, attorneys are very much involved in negotiating deals or preparing for a jury trial. Most people start off and want to take a jury trial, but a jury trial is an expensive and frightful proceeding. And most people relent when they're threatened with the amount of time that some of these crimes carry, and they'll enter into a guilty plea. As I said, information is vital. It's a critical component of understanding, where you're at and what you're going to get. A guilty plea is a contract. And in that contract, there's a lot of loopholes. And it's governed by contract law. I think I might have said that too in a previous episode. But we want to pound it in until it becomes a part of every part so that you understand clearly the decision that you're going to make. Now, education also comes into play. It's the second component of what ReformCrimeSentencingNow.org tries to illustrate, express, and demonstrate. And what I mean by education is we express that it's critical for anybody that's sitting in the county jail, sitting in the city jail, or sitting in prison to take it upon themselves to abreast themselves with, first and foremost, the constitutional rights and understanding the constitutional right. As the Constitution is written, that doesn't necessarily mean that it's going to be reflected by a court of law. So this is because, it's so broad. The Constitution isn't that broad as far as the amendments are concerned that apply to each citizen of this country. What's broad is the precedent that defines and shapes the Constitution that you hope will protect you. So education is critical, that you grasp your rights, and then everybody out here has a phone, I would imagine, and you can pull your rights up, and there's case law, precedent that supports how those rights are being applied to you. And that's the reason why there's so much change going on with the law, and because it has evolved during the last 50 years immensely. And it's, as I said, it can be shaped by the Senate, not just the Supreme Courts and appellate courts. It can be shaped by Congress also, and because Congress are the lawmakers, they're the ones that pass law. All the courts do is come back and interpret the definition of the laws that were passed, and if it conflicts in a way that's arbitrary to the freedoms that you're guaranteed under the Constitution, they can come back and change the laws that Congress passes. And most times we have learned throughout the history of the United States when Congress has passed the law, they have passed laws that are arbitrary, draconian, and just downright unfair. And sometimes it takes 30 to 40 years to get those laws overturned. And that all depends on who the judges are, what political party those judges were appointed by, influences from outside concerns, such as the community. I happened to receive a YouTube video of the brother that's a comedian, David Chappelle, and he was being interviewed, and they were talking about opioids, and the guy that was doing the interview stated, asked Dave Chappelle the effect of opioid in the United States, like fentanyl, the effects of fentanyl in the United States, and David Chappelle gave a good, resounding answer to that question. He said when opioids hit the country and affected a suspect group of individuals, everybody called for an epidemic. He said, now, let's go back in time. I'm paraphrasing. I'm not saying exactly how he said it. Let's go back in time. When crack cocaine hit, everybody called it a crisis of criminality. And he differentiated based upon the fact that when crimes affect one nationality of people as opposed to another nationality of people, they want to say it's a crisis of major proportions, and we need to get tough on crime so that we can eliminate crime. Fast forward to now, and it's a different story. And we as a community, in educating ourselves, have to be conscious enough to know that you can't simply be told something. And that's what happened back in the 70s and the 80s with the crisis that hit our community. You know, a lot of people just didn't care. They were scared to death because of the type of crimes that were going on in the community. And so they just laid it at people's feet and treated them as, you know, they deserve to be locked up for the rest of their lives. And in all actuality, when you go back and look at the charging instruments in those cases, you see even though it was drugs, and some drugs, you know, which I'm not trying to justify, some drugs are worse than others, they created draconian laws. And 30 years later, they're finally trying to get around to eliminating some of the draconian laws that were enacted back in the 70s and 80s. Now, I would hope that by utilizing the apparatuses that you possess every day in your hand, that you go back and look at some of this, some of these laws, some of the legislators that are still in office today, creating and opposing laws that benefit nonviolent offenders. You know, and again, you can believe what someone else says, but you don't know. You simply guess that what they're telling you is right. But you got to be what you know. You can't just speak to a thing or blurt something out and you don't know what you're talking about. Just because so-and-so said this doesn't mean that it's true. You know, you can't just take a person at face value because they dress themselves up, like me, and put on a white hat and say that they're righteous because they got elected to office, because they were shrewd enough to have a polished coat at the time of election. But during the course of their career in public office, how many people have been charged with criminal offenses against the public? So again, everything is not what it seems. Skim milk masquerades as cream. So I would hope that I've said something that you could use, and you can go online and find reformcrimesentencing.org. We have a lot of material online on Facebook also, and utilize some of that information to help your loved ones deal with the issues that they're confronted with day in and day out. For those of you who watch the nightly news and listen to radio shows, D.L. Hughley's a great show to listen to. I mean, he gives you the 411 on things that are relevant to the safety of everybody's community. Not just a few, but everybody's community. And I don't want to beat a dead horse, but violence is rampant at this hour in the United States. And lawmakers and politicians are slow to adjust some of the more viable proposals that are before Congress to loosen the reins on severe sentencing. So you need to be focused on that. We have a lot of people incarcerated for nonviolent offenses that are suffering the ramifications of the violent conduct that is occurring in our communities today. For the young men and women out there, reckless, not thinking, not understanding the consequences of their conduct, especially you need to be focused on what it is you're doing and the consequences of those particular acts. It is my hope that, again, that you have taken something worthwhile from this discussion and apply it accordingly. Hopefully in the future we hope to get out into the different and surrounding communities and put on seminars and workshops that will benefit some of the youth in our communities and help deter and stop some of the gun violence that is occurring. You have many factions, many cultures that are living in cities now. Some of these cultures and factions are being blamed for the influx of drugs coming into the country. And again, getting back to the politicians and the lawmakers, a lot of this may be true. I haven't seen no evidence of it. I haven't seen much evidence of it throughout the media. So mine never does forget, as I read case law every day in my research for putting together what is called The View on our Facebook and .org page. I see that dating back to, again, the 1800s, these type of assertions were made against people who had migrated to the United States. And they attributed certain narcotics that were illegal to these cultures, and as a result, punished them severely. I think that this has to stop. And I think the only way that can be stopped is that the public, again, and I'll probably say this during every episode I have going forward, the public, again, has to be mindful of the people who are getting elected to these offices. And that makes all the difference in the world. And I don't want to sound like I'm singling out a particular nationality of people, because you can go back in the 80s and you can see all the African Americans that were lawmakers, community leaders, things of that nature, supporting that 100-to-1 ratio. You know, the C-SPAN, CNN, their archives have all this information in it. And you can look at that and see how some of the same people today that are getting up, hurrahing the change in these laws that are afoot today, supported those same laws back in the day. And that makes a big difference. And we need to hold our people accountable also, as our people have held us accountable for things that weren't even what they said to be. Like I said, everything's not what it seems. Skim milk masquerades as cream. And with that, I bid you a very, very good night. Thank you.